And thank you again for taking some time to join us. We definitely appreciate you tuning in and getting to learn a little bit more about estate planning, or if you're just starting the journey, a lot more. All right, so I'm going to get us started. That way I can keep those of you here on time. So my name is Victoria. I am one of the estate planning attorneys with the Copenbarger law firm. One of the things that we take very seriously at Copenbarger is making sure that our clients have access to education events. We want to make sure that you have the awareness of what is it that you need to make sure has been done, or if it hasn't been done already, what do I now need to come in and do? So as I briefly mentioned, as we were all getting settled in, if you have any questions or things that you would like specifically addressed that we're able to today, please put them in the chat in the Q&A for us. Now, one of the things I really like is checklists. I like to know when I start a task, if I have anything to do, if I'm trying to get it off of a to-do list, I like actual lists. I like seeing that it has been checked off and that I can mark it as complete. Well, for us, estate planning is no different. With your estate plan, you should think of it like a checklist. Have you completed all of the tasks that need to be completed? And have you kept up to date on all of those different things as well? First and foremost, though, before we jump in, I do want to go over a little bit about who we are, especially for those of you who have never met with us before. But even for those of you who have, we have a couple of new faces that have joined the team. So we're one of, if not the largest estate planning firms in the state. The reason for that is not only because of the number of attorneys that we have, it's also the number of departments that we have. So our estate planning department is the heart of what we do. We're looking to make sure people are protected not only after they pass away, but even during their lifetime. We want to ensure that your wishes are the ones carried out, not the courts, not some random family member, not someone you've never met, but yours. But after you pass away, we also want to make sure that you or your family are taken care of at that point. That is done through our estate administration department. This department is there to walk alongside your family to make sure that the tasks that need to be accomplished are, and that actually they can hand a lot of those tasks off to one of our attorneys so that they don't even have to think about it. They know it's being done correctly, and it takes a weight off of their shoulders. We also have our business and tax department. This department is there to ensure that if you have any advanced planning issues, if you have more specialized planning concerns or needs, that these can be addressed in-house as well. For many of our clients, they want to include charities in their planning. And for some of those clients, how they want to give goes beyond just a basic gift. They really want to establish a foundation, a legacy, something that will continue on. And that is where that department comes in. The other piece that unfortunately we know is that especially after someone passes away, people can do things that even in the most sane of times, they wouldn't have ordinarily done. And after someone passes away, it's not a simple time. It is not a straightforward time, and it can cause the most sane of person to do things again that they ordinarily wouldn't do. And a lot of times that involves fighting and can even involve fighting in court. And so that is where our estate litigation department comes in to take care of any of those issues. But we couldn't do what we do without our staff. So our staff is the reason that we are able to help so many people and have been able to help them for so long. These wonderful people make sure that our client needs get answered as quickly and efficiently as possible to make sure that you know your team is there working for you. We also have offices all over the state. So the great thing here is not only if you move, is there likelihood within California that we have an office near you, but if your family lives outside of your area, we likely have an office for them as well. But we can also always do things on Zoom and over the phone. All right, so let's get started. So we want to make sure that your checklist is completed. Now, at the end of this, if you find that there are any things on that checklist that are not completed, I encourage you to take advantage of the free consultation you are entitled to as a result of watching this webinar. Any of the education events that we put on entitle our clients to those free consultations, whether that's to set something up or just to look over and make sure you have actually completed that checklist accordingly. The first one that we want to go through is, have you even started your estate plan? Do you have the essential documents that are necessary to make sure you, your family, and your estate are protected? So first and foremost, Anytime we're talking about estate planning, we're talking about a comprehensive set of documents. There is no one document that is going to completely cover you from a protection standpoint. You need at least 2 of these, and generally speaking, up to 4. So the first one that you absolutely have to have, and the question right now is, do you have an Advanced Health Care Directive? And has it been done since 2004? Is this healthcare directive? Do you have one in place? The healthcare directive is probably the most important thing to make sure you have it done, that it was completed after 2004, and that it is still relevant and current. So I'm going to walk through each of those and why they're important. First and foremost, do you have one at all? This is the document that will actually give somebody else the authority to make your medical decisions if you no longer can. And it also actually answers some of the questions that they will have to answer at the end of your life. This could be life support, organ donation, things of that nature. The second issue here is, was it done after 2004? In 2004, privacy laws under HIPAA changed. If it was not done after 2004, so you did it before 2004, it is actually no longer valid. So it is really important to make sure, again, not only do you have one, but have you had it done since 2004? And the last part of this checklist for this document is it still relevant and current? So you have someone in place, you've set it up, let's say 2005. That's quite a bit of time now that has gone by. Not quite 20 years, but we're getting close. The problem in those, let's say just 20 years to use a round number, is a lot of things can change. Who you named back then may not be the same person as you would want to take care of you now. Maybe the person has actually passed away. Maybe you had minor children and now they're adults and they could make the decisions for you. So again, it's not only important to have one and have one since 2004, but it is extremely important to make sure it is still current for who you would actually want to make those decisions if you were in that vulnerable state. The second document that you absolutely need to make sure you have done, so the second one on your checklist, is, do you have a durable or financial power of attorney, and was it done in the last 5 years? So again, let me break down why these 2 parts of the checklist are important. First and foremost, do you have one at all? This is a document that says if you are incapacitated, who is going to get to make your financial decisions? Who will be able to pay bills and manage your life financially if you are alive but unwell? This is a vitally important document because this could be you're just recovering from surgery, or this is you're permanently incapacitated. Either way, somebody's got to write those checks to keep the lights on. Somebody has to make sure the bills are paid to the people who are going to be coming and collecting. This is one of those documents that is very simple to have done and has a lot of weight behind it. The other thing, though, is it needs to have been done in the last 3 to 5 years. The reason for that is banks are no longer accepting them if they are older than 5 years old. Some are even more restrictive in saying 3 years, but most banks accept them if they're 5 years or newer. If you have one that was done before 5 years ago, unfortunately, what banks are basically saying is it's out of date. We don't trust the person named is really who you would want, so we're not accepting it. Now, for a lot of us, we go, it's the same people. We don't really have updates. It's still going to be my spouse. It's still then going to be my kids. Why do I need to update it? Well, the reason is for, unfortunately, some of the not great examples that we see. I had a client who she and her nephew came in. She was completely distraught because when she had originally done her documents, she had named her son as her power of attorney. In the time between when she had done it, which was about 15 years ago, to now, the son had unfortunately used that power to pull money, the equity, out of her home and use it for himself. And because he had a power of attorney, he was truly able to do that without really any question. Now, the institution should have absolutely asked more questions. They should have done additional research, but they didn't. They just relied on the authority of this document. So banks are trying to avoid those sort of situations by saying, if you haven't kept it updated, if it's not current, we just assume it's not relevant or valid anymore. So this is one that, again, you need done, and you absolutely need it updated from the last 3 to 5 years. The other issue with not having these two documents checked off in your checklist is if you do not have these completed and you become incapacitated, we then have to go to the court and ask them to appoint who gets to take care of you and who gets to take care of the money. Those two questions that could have very easily been answered ahead of time had you put those two documents in place. Everything we talk about for our estate planning clients is how to avoid the court and how to make sure the control remains in yours or your family's hands. And those two documents are the cornerstone of how to do that if you're alive but incapacitated. So again, the two things we're starting with on that checklist: do you have that healthcare directive? Do you have your financial power of attorney? Now, the next question is, do you have a will and/or do you have a trust? The reason this is a absolutely vital part of the question is you need to make sure you have the right document in place. A lot of people come and they say, I need a will. Okay, let's find out why. So we start asking questions. Okay, do you have minor children? Yes, great. Yes, you will need some kind of a will because that is where you name guardians of your children. Do you have more than $184,000? No, I really don't. Okay, great. A will still might be enough to cover you. Do you own property? Yes. Okay, that flags. You're not then able to have just a will. The only people who are completely covered, or at least covered enough under a will, are those with no property and less than $184,500. The reason for that is the probate court. Court has said, or the state of California has said, that if you pass away and you only have a will, but you owned a piece of property, or you had more than that $184,000, that you do not have a document adequate enough for them to not get involved. You have not completely answered the questions that they need answered. They need to know who is going to actually be in charge of settling your estate. Now, your will is where you would have named someone, but the court now has to actually approve that person. They do not have to approve that person. The court needs to decide, did you owe any debts? Does anyone owe you money? So is your mortgage, if you had an outstanding mortgage or a car loan, are those things now due immediately or can they be paid over time? And ultimately, where does your stuff go? Again, you may have put it in the will, but the court ultimately gets to make it clear, yes, we'll follow that, or no, we will not. And so again, this takes the control out of your hands. It takes the control out of your family's hands and puts it squarely then in the courts. So the great news is you can avoid that. So again, let's go back to the checklist. Do I need a will or do I need a trust? Well, if you own property or you have more than that $184,000, your checklist needs to ask, do I have a trust? If you're answering no to that question, your estate will go through probate when you pass away. So a trust is there to answer all of the questions the court says a will did not. It answers and appoints and approves who is going to manage things when you no longer can, who will settle things when you are no longer here. It answers what happens with debts. Do they have to be paid immediately, or can they be transferred over to whoever now owns that property if they're able to? And ultimately, you get to decide who gets to inherit from you. That is probably one of the most crucial points because inheriting is not straightforward. It's not cut and dry for most people. If you have minor children, there's a lot of conversation that goes into how and when a minor child will inherit. If it's an adult child, okay, great. You may love your child, but are they the most responsible person? Are they really equipped to manage an inheritance? What if you don't have children? Then who's going to get it? All of that is to say, your trust gets to be in your hands, and so you get to decide who's getting what and when. Now, one of the other big benefits outside of avoiding probate is that your trust also allows you to do advanced tax planning. A lot of people say, well, I'm not in the uber wealthy. Why do I need to worry about estate planning? And sure as heck, why do I need to worry about tax planning? Well, because unfortunately, taxes affect all of us, whether we like it or not. And they are everywhere. I don't think I ever fully realized how many taxes there really are until I started learning how to avoid them. We're talking about income taxes, property taxes, capital gains taxes, it's gift taxes, death taxes, you name it, there is unfortunately a tax. The good news, though, with your estate plan, and especially with your trust, is that you can, at a minimum, reduce unnecessary taxes, but in a lot of cases, eliminate. And notice I say unnecessary taxes. The government, the IRS, they're not going to give money back to you if you have not done something to protect it from them. They're more than happy to take a little extra if you have not done planning to keep them from doing that. So our job is to make sure that legally you don't pay a cent over the tax requirement that is going to be there when you pass or even during your life. The other point, again, that I can't stress enough is that when we're answering all of these questions, we're making sure it is that your wishes are the ones being carried out, not anyone else. So that is a huge piece of why we do what we do. We don't want the court answering, the IRS, even your family answering. It's your estate, it's your life, and you should have that control. Now, that's the basics. That is, do you have these documents? So do you have your healthcare? Do you have your financial power of attorney? Do you have a will? Do you have a trust? Do you know if you need one or the other of those? If you still have any questions on which ones apply to you, use that free consultation to come and talk to us. If you need to establish those, use the free consultation. And if you need to review what you already have, again, use that free consultation. So next up, let's talk about, have you thought about the legal changes that may be affecting you? So one of the big questions on your checklist should be, have you met with your Copenbarger attorney in the last 3 to 5 years to ensure that any legal changes that have occurred have been accounted for in your documents? We recommend people meet with us every 3 to 5 years because life changes and the law changes. What that then means is a lot of times your estate plan needs to adapt to comply with especially the legal components that may impact you. So I want to focus at this part on the legal pieces. If you have not seen us since 2018, you do not have all of the protections that our documents currently afford. So it's really important, again, make a note. If you haven't seen us since 2018, now is the time to come in and talk to us because the law has changed. And as a result, your documents might need to as well. The first big legal change that I want to talk about is the Secure Act. Now, this one not only involves talking to us, it may also involve talking to your financial advisor. The Secure Act is a rule that changed back in January of 2020. It's dealing with your IRAs and 401ks, anything that is a retirement account that can be taxed once a beneficiary receives it and then inherits and starts taking that money. With the Secure Act, it did actually a few things that were positive. Now, on this front, this is absolutely where I say talk to your financial advisor. And if you don't have one, we have great recommendations for quite a few that you can talk to. The reason for that is sometimes what you need goes beyond just the basics of estate planning. Sometimes it is, what am I going to do with my money and how is the best strategy to use it? Now, going back to the us part of it, the thing we want to make sure you're all aware of is that when a beneficiary, outside of really a spouse for the most part, inherits an IRA or 401k, rather than having their lifetime to take the amount and use just the required minimum distributions, they now only have 10 years to withdraw the entire amount. Now, they can break that up over those 10 years however they want to. But again, they only have 10 years. So if, God forbid, you pass away and your children are still young, they're, let's say, in their 50s, they could have another 15 plus years that they want to work. Well, if they're going to work for another 15 years, but they only have 10 to withdraw this retirement balance, that adds to their income. And so now the taxes are going to be significantly higher. The reason we bring this up is twofold. One, again, talk to a financial advisor, which I'll cover at the end of this as well. Utilizing your advisor to make sure that not only are you strategically planning your finances for your life, but also are you really ensuring that they're strategically planned for after you're gone is a huge component of what we talk about. The other side of it, though, is in your trust for Copenbarger, there is an entire section on retirement. If the current section does not comply with the current law, there can be even additional consequences and penalties that may apply to that money. So again, it's important to make sure that your trust is updated where necessary to comply with what the law says today. The next one is, again, it's a tax. So as I mentioned, there's taxes everywhere. So that's a retirement tax for after you pass away. This is a tax dealing with you've passed away and what's happening with your property. Proposition 19 has had profound impacts on the ability for children to keep their parents' properties. If you have a secondary property and a child inherits it, under Proposition 19, it will be reassessed when they inherit it. Period. End of story. For your primary residence, the only way for it to keep your tax basis is for when a child inherits it, for them to own it and live in it as their primary residence indefinitely. They could own it for 15 years. If they turn around and decide to turn it into a rental, taxes go up. If they live in it for 1 year, decide to turn it into a rental, taxes go up. So unfortunately, again, this has very much reduced the ability for kids to keep their parents' properties, because property taxes today are a heck of a lot higher than they were 10, 20, 30 years ago. Now, again, though, there is language that we can put in to at least maximize the ability for kids to keep your tax basis. In the example where you have 3 children, your current distribution says my 3 kids get everything equally. So the property pays out 3 ways. Child A, child B, child C, they all have a third. And child A says, well, I'd really like to own it and live in it. Can I buy you guys out? So they transfer cash. She transfers cash to the other 2. The other 2 transfer their interest to her. Great. The problem is now you've had a child-to-child transfer. So what happens is 2/3 of that property will still be reassessed. So the language that we put in your trust is child A can use what's called right of first refusal to buy out the other 2 before the distribution has actually happened, which still then keeps it as a parent-to-child transfer, allowing child A to keep the entire property tax basis and giving cash to the other 2. So everyone still walks away with 1/3 of the value, but child A now gets it in the property and does not have a huge increase in property taxes. But again, that is language that needs to be in there. So if that is a concern at all, come and see us. Now, one of the other pieces that is a good piece, and it's not right here, but is if you are planning to move, do let us know, because now if you're over 55, you can transfer your tax basis up to 3 times in your lifetime. The other piece that is, if you are planning to buy a new piece of property, absolutely come and talk to us ahead of time. Utilizing, again, our business and tax department and LLCs, there are additional ways you can help avoid this. Other than these things, though, the properties do get reassessed. All right. One of the other pieces, though, just to keep in mind, is another big question we get is, well, okay, should I sell or gift the property to my children while I'm alive? Is there any way to avoid the taxes later? Is this a good idea? Gifting it now does not avoid the Proposition 19 problem. It's when it transfers from a parent to a child, it doesn't matter if that's during life or after you've passed away. The other piece, though, is if you transfer it before you die, they can lose significant capital gains advantages after you passed away. So when a property transfers to frankly, anyone, after you pass, that property gets a new value as of your date of death. If the beneficiary then turns around and sells it for that value, they do not pay capital gains taxes. So what that means is even if when you purchased the property, it was $15,000, so a very low value property in today's society, but it's now worth $1 million. If you wait until you pass away for it to transfer, it will be set at the $1 million. And if they sell it then for $1 million, they don't pay capital gains on what you would have had to during your lifetime. Again, there's a lot of taxes at play here. If you have more questions, absolutely come and talk to us. Now, another big rule shift that happened that frankly not many people were aware of is the Medi-Cal changes. Medi-Cal used to be that if you owned more than $2,000 and your primary residence, you could not qualify for Medi-Cal. They actually raised it July of last year to say you could now have your primary residence and up to $130,000. This was a huge, kind of unforeseen and unexpected shift. And so what it meant is a lot of people who either had already been disqualified or had never tried to qualify because they wouldn't have, now actually could. We have people that help us qualify our clients for Medi-Cal. So if you have any questions on this, again, come and talk to us. There is another huge phase, though, coming in just a couple of months as of January 1st of 2024. What Medi-Cal is currently saying is that as of January 1st of this next year, they're going to remove asset restrictions for Medi-Cal. In theory, what this means is that anyone can qualify for Medi-Cal. What we are, though, fully expecting is that they will limit people based on income. Now, we have had a Medi-Cal trust for, I think it's now over a decade. Time has flown, that has allowed people to preserve their assets and still qualify for Medi-Cal. What we are working on now is a way for people to preserve their income and still qualify for Medi-Cal. So if you have any questions on how am I going to afford Medi-Cal, how is my parent going to afford it? Am I going to have to now be stuck paying out of pocket for their care? Come and talk to us. There are still options available, but as things are changing, again, we need to make sure your plan accounts for those as well. I cannot also stress enough that qualifying for Medi-Cal is very complex, not only because the rules are changing, but also, very bluntly, no government entity wants you to qualify easily. They are looking to disqualify people. So a lot of times the forms they may send seem extremely straightforward, but if you answer even one question wrong, they don't have a second chance. They will send you a disqualifying letter. Very few people get a chance to amend what they have sent to fix it and update it. Most people just get, you don't qualify, sorry. And they're stuck trying to figure out why. They're stuck trying to figure out, can I now try to qualify again? We are there to make sure that you avoid that pain and that step. Doing it right out the gate saves you time, heartache, and frankly, money in the long run. So again, all of this is to say, come and talk to us. So that's on your checklist. Have you seen us in the last 3 to 5 years to make sure any legal changes have been accounted for in your trust? The next question is, have you seen us in the last 3 to 5 years to make sure if your life has changed, that your trust accounts for those? One of the biggest changes that people experience from an estate planning standpoint is that your children went from being minors when you started to now they are adults. And they are adults with their own lives, their own spouses a lot of times, and their own children. Well, that comes with a whole new set of questions, not only for them, but also for you and your plan. Are the beneficiaries still the same? I had clients just a couple weeks ago, and on their trust, they had one child. And as we were talking, I all of a sudden went, have you had more children since we saw you? They had 4 more children in the time when we had originally seen them to the time that they came back. And so with their plan, it identified 1 child. That was it. The other 4 were not mentioned. They were not accounted for. They were not planned for. Now, thankfully at Copenbarger, we do things to ensure that if that happens, those kids would have still been taken care of. But what happens if you have the 5 children and you have it that you've only accounted for 1? And if you have any others, they're all getting an equal distribution, and that's that. But of those 5, you have 1 that you no longer talk to. Those are heartbreaking stories, but they're ones we hear a lot. You're estranged from this child. You don't at this point know where they are. You don't want them to receive anything. And you have another child who has an alcohol dependency problem. Should each of those kids then get the exact same distribution, and should they all be inheriting in the same way? Or does there need to be advanced protections around some of them, all of them, or none of them? So has your life shifted from a beneficiary standpoint? Were you at a church in San Jose when you started and you wanted them to receive something, but now you've moved down to Orange County and you're at a completely different church? Would you want your new church family to receive that gift? Or do you still want it going to San Jose? Again, these are questions that as your life changes and your priorities and beneficiaries shift, your trust needs to account for them as well. And then again, how is your health? When a lot of our clients start, their health is at a very different place than when they come and see us 10, 20, 30 years down the line. So again, we need to make sure that you are adequately protected and provided for, frankly, before anybody else. Now, again, biggest change we see is minor children are now adults. So this has a slew of conversation and changes that can come with it. First is, do they need their own protections? As soon as they turned 18, you lost the ability as their parent to make their medical decisions without their verbal or written permission. And the same goes for finances. So they may need their own documents in place at that point. The next question is, okay, they're now at an age, they're mature enough to manage things if you no longer could. So do you want them to be your successor trustee? Do you want them to be the one making medical decisions at the end of life? And again, just because they're adults, just because let's say you have those 5 kids, you've got eldest to youngest, does not necessarily mean you want it eldest to youngest. A lot of times we actually talk with people where the youngest is now the most mature. So they're the person that should be in place. And the oldest, not so much. It just depends on your circumstance. So this is where we need to make sure we're really talking through what does your life look like and who is the most appropriate person to be in these different roles. Again, are your beneficiaries still the same? Have you gotten married or divorced? Well, if you especially have gotten divorced, would you now want your ex-spouse making your medical decisions, including pulling the plug? Do you want them inheriting your money? Most people answer no to that question. If you've gotten married, well, do you now want your spouse to make some of those intimate medical decisions? Do you want them to be left with financial resources after you pass away? Again, a lot of people say yes. What happens if you have a blended family? That means it is not always cut and dry for who's going to inherit what, when, and why. And so blended families can make for a lot of different changes in your distribution. You've moved. You've kept your house, but you refinanced. Is that new property, is that refinanced property still in your trust name and protected? What happens if your children get married? Well, you may love them, the spouse or the in-law currently, but what happens if your kids get divorced? Or what happens if that in-law outlives your child? Would you want them to take the money to a new family, or would you want it to guaranteed stay in yours and pass down to grandchildren? Again, there's a lot of questions that go into this. If you have gotten married, one of the things we'll talk to you about is an AB trust. An AB trust is there to essentially protect that if your spouse outlives you, they could not give your half of the estate away to anybody else. Whether they get remarried, whether they just change priorities, your half of the estate becomes locked in place, so it can't be given away to someone else. Again, what happens if you get a divorce? Making sure that your estate stays in your family and is not just depleted and eaten up or given after you pass away to a now ex-spouse. I mentioned what happens if you want to make sure that your estate stays in your family. One of the main ways that we do this is by using what are called GSTs, or lifetime protective trusts. These are trusts that ensure that after your children receive their inheritance, any outside predator cannot take that inheritance away from them. If they get a divorce, it does not get considered in the divorce proceeding. If their spouse outlives them and remarries, it cannot go with that person to a new family. If they're in a car accident and it's 100% their fault, their money, their inheritance cannot be taken to satisfy any lawsuit or legal liability. So it insulates it and ensures and says when they pass away, it will drop down to their children if they have any, guaranteeing it stays in your family line and doesn't go anywhere else. So again, for the checklist, do you have this in place if you want it? And if your answer is no, come and talk to us. Another big one is, do you have minor children? Let's say when you started, you had no children at all, and now you have young kids. There's a lot of conversation that goes into this. Not only who should be the guardians if God forbid you pass before they hit 18, but also let's say they do live past 18, but you pass when they are 21. Well, is 21 really the age that you want them to receive an entire inheritance when generally at 21, they're experiencing life in a new legal way, hopefully for the first time? That is often then not the time that you want them to just be handed unbridled money where they can just go spend it however they now want to. So you can do staggered distributions. You can just say it'll be managed until you reach X age. It can be used for your living, for your food, but you can't go and spend it on the new Lamborghini that just came out. It's got to be used to take care of you. But then at a certain point, yes, we're hoping you're mature enough. Here's the money. You can do with it as you see fit. So there's, again, a lot of conversation that goes into not just what happens when they're minors, but also just because they're 18 does not necessarily equal maturity. And again, making sure, especially when we have more vulnerable beneficiaries, which includes our special needs beneficiaries, have you properly provided for them? A lot of our special needs children parents come in and they will say, well, I don't know how to leave the money. They're on government benefits. I don't want them to lose their program benefits. The great news is by utilizing a special needs trust, they can keep those benefits and receive an inheritance that can then be used to supplement their care and make sure that they are still provided for in the way that you would want them to be. Truly, all of this is to really hammer home your trust and your estate plan are able to provide and protect those you need and want to. All right. Nope. Jumping a couple more. Another big piece on your checklist is, have your finances changed? I mentioned a little bit ago, have you refinanced a home? This is one that comes up constantly. We will ask when people come in for their review appointments, have you refinanced your home? Is your home still in the trust? A lot of people will say, yeah, the home's in the trust, but yes, I also refinanced. The problem with most refinances, in fact, I've only met one company where this was not a problem. Most refinances pull the home out of the trust and the company never puts it back in your trust, which means your home is left vulnerable to probate after you pass away if it was not put back in your trust. This is a huge step that most people don't realize has occurred because the refinance company doesn't say anything. In fact, a lot of their terms say they will put it back in the trust, but it costs them money to do that. They have to then pay a recording fee and they choose or forget or whatever you want to say, but they don't do it. So if you have refinanced, absolutely double check, is your home still in the trust? And if you can't do it or you don't know how, we can do it for you. If we find that it was not put back in the trust, we need to do a deed to do so. Again, though, with your finances, have things changed? Have you opened new accounts? Have you put those in the trust? Have you closed accounts? Well, that's a big one because we create schedules of assets for you with your trust. One of the things with those schedules of assets is it gives your trustee a blueprint of what you have at the end of your life. Well, if you never update that schedule, you never put new accounts on it or take old accounts off, it can lead to a lot of confusion for those people. So if you have any questions on what you should be doing with your finances as far as the trust goes, again, I'll keep saying it, come and talk to us. Now, shockingly, we are getting to the end of the year. I don't frankly know how that happened. It feels like this year started slow and all of a sudden we're middle of October. But as the end of the year happens, it's the end of another tax year. And so not only do we want to make sure your checklist going into the holidays is completed, so it's one less thing you have to think about, it's also important to make sure you've taken full advantage of some of the other pieces of a tax year. One of the big things is, have you gifted to charity? So, or frankly, have you gifted at all? With gifting, currently, the rule says that each individual can give other individuals up to $17,000 without ever having to tell the IRS that you have done so. Have you taken advantage of that? Especially if you have an estate that is a higher net worth, we want to make sure that this is something you are aware of and that you have taken advantage of. Have you planned for other asset-based giving? Have you planned correctly for income taxes that may be there? This is, again, where we pull in a lot of times CPAs and financial advisors. A lot of people don't understand that they can offset certain gains with other losses. These are things that you don't want to wait till it's all set in stone and you're stuck with whatever happened this previous tax year. It is time before the end of the year, before December 31st, that any of those things that need to be adjusted or accounted for to lower any tax liability you otherwise would have had are done now. Again, don't wait till the first of the year because then it is locked in place. One of the big things, though, as far as charitable giving is it does, again, allow you to have deductions, which means there's more money left in your pocket versus the government, which means you have more money to give to whomever or whatever you would want to. One of the ways that we accomplish this, I briefly mentioned it, is by using charitable trusts. Charitable trusts are advanced ways that you can leave charitable gifts either during your life or even after you've passed away. So come in, talk to our business and tax department to see if you have more advanced charitable giving intent, how that can best be accomplished. Let's see. Oh, I'm going to pause. Okay, so one of the things that was a concern that I did not address was, why are co-trustees a danger? So I'm actually going to go back to that slide just so that you can all see what am I talking about. Okay. The reason we say co-trustees danger, Will Robinson, is because a lot of times when you have especially just two children, people say, well, I just want my kids to be named together. I want them to have to do it all together, and that's that. My follow-up question to that is, do they get along? Do they have the same values, morals, religion, principles? Because if they do not, and you put two people as co-trustees, this can be an absolute recipe for disaster. Co-trustees have to do everything together, and they have to then be liable for the other one's actions. If they do not get along, if they do not see things eye to eye and in the same way, this can again have catastrophic results, including things just don't get done. And it's important to know with trustees, a lot of times they don't come into play until after you've passed away, but they absolutely can if you're alive but incapacitated as well. Once you're gone, co-trustees not getting along, it's more frustrating for everyone else than obviously it will be for you. You're no longer here. But if you are alive and the co-trustees need to agree what assisted living facility you're going to be put in, how are those bills going to be paid? Do we turn the property into a rental? Do we keep it as a residence? What do we do? If they can't agree, again, it can have catastrophic results for you and your care during your life. There's a lot more conversation that often goes into that, but it is why with co-trustees, just because that seems like a great idea on the surface, doesn't always mean it is. At the end of the day, though, it is your trust. And I have had clients who say, yeah, they don't get along, but I want to force them to have to. They're the only kids. The only damage they'll do after I'm dead is to themselves. They won't get their money. It's their problem to deal with. And I say, okay, as long as you're aware of the risks and concerns, great. But it is something we need to make sure is brought up. All right, jumping back forward. Sorry about that. All right, a little hopping. Again, as we're coming to the end of the year, have you already met with your CPA? Again, start talking about these things now. Have you checked in with a or your financial advisor? If your answer is no, absolutely check in now, because if you have required minimum distributions and you miss those deadlines, again, that can have huge results or impacts after the end of the year. Have you checked in with your insurance carrier? I love the holidays. Christmas is probably my favorite time of year, but unfortunately with Christmas, it does mean there are more accidents. People are out there with saws and axes cutting down trees. Most of us don't use saws and axes all year long, but out we go to get a tree, and now we're using them. We're getting on roofs, we're hanging lights, we're dealing with a lot more electricity than we might all year long as far as plugging different things in and unplugging them, maybe not always the safest way. People are drinking, they're cooking, they're doing all of these things that can unfortunately lead to accidents, even in the most fun of times. So it is also very important to make sure, have you checked in with your insurance carrier to make sure, if God forbid an accident occurred, you are going to be protected, whether personally or because somebody else got hurt on your property and now they're trying to get some kind of settlement out of that injury. Now, the last piece to quickly go into is, have you discussed your personal treasures, so to speak? Have you discussed and planned for your online presence, your digital assets, your emotional things that you have? With social media and your digital presence, this is a huge one a lot of people don't actually think about. After my grandma passed away, I was so relieved I had access, as much as she didn't use Facebook, to her account, but also to her phone. Because especially with the phone, it had all of the contacts for people we needed to let know she had passed away. Without that, it would have been nearly impossible to figure out all of the people I had never met that would have wanted to know she was no longer with us. Same with emails. She had a lot of great information. She saved recipes in emails. It was great to be able to utilize that and make sure not only did I have the technical stuff I needed out of it, but also some of those personal mementos. Cryptocurrency has become a huge part of the financial landscape and conversation. Now, one thing to note, at least as of today, is that cryptocurrency is still considered a personal asset. What that means is it is not treated the same as cash and other financial means. It is treated as a personal property asset. Now, with cryptocurrency, if you have it, you very likely understand it then passes by a code or a keychain or some kind of number system or letter system. And if someone does not have it when you pass away, 9 out of 10 times, if not more, it then just disappears. It is an asset that does not properly transfer, and there's nothing anyone can do about it. So if you have questions on cryptocurrency and how to make sure that transfers when you're gone, do come and talk to us. But then another big one is with your family history and mementos. Have you put in place what's going to happen with things, your things, not just your cash, when you pass away? A lot of times this is the piece that has more value for family than anything else. When you're alive, a lot of people say, I don't want it, I don't need it, get rid of it. But when you pass away, those things become you. And that emotional attachment attaches once you are gone. So have you planned for that? Have you left those stories with the item? Have you explained to your loved ones why something has a lot of family history or value? That can have, again, profound impacts on your family and even those items. But a big thing is, again, have you actually done any of these things? So we have clients who have done a myriad of different things to show and capture that value, that emotional value. So if you haven't done this already, but you're not really sure where to start, here's just a couple of ideas, but we're happy to share any others that we have. Now, one of the other pieces, though, is that does your trust allow you to leave items to specific people? So with your stuff, a lot of times we talk about with our clients, do you have anything that a specific child or family member or friend would want? And if the answer is yes, and you have a Copenbarger trust, we then say, okay, great. Have you used a memorandum or letter of instruction to leave that item to that person? And a lot of times people say no. In our trust, we have the ability for you to, without changing the trust itself, which very bluntly means you don't have to pay your attorney, allows you to leave items to specific people. So what that means is if you want to leave, I'll use my mom and her grandma, for example. My grandma had a handwritten Bible and she wanted my mom to have it. So how she did it is she left a letter that says, I want my granddaughter Kelsey to receive my Bible. And she described it in actually quite a bit of great detail, and then signed and dated it. So when she passed away, my mom was able to have that. So you can, with a Copenbarger trust, utilize those letters and do that for as many items and to as many people as you want. Now I'm going to pause really quickly for a question that I just saw. How do California-related laws apply if you no longer live in California? A lot of laws in estate plan are actually extremely similar from state to state. Now, if it is something like Proposition 19 that is 100% a California law, it will not apply to your non-California properties. But if it is something like the Secure Act that does impact California, that is a federal rule that will impact you no matter where you go in the US. So as far as California laws, the literal state California law may not apply to you, but a federal one still will, and it may be extremely similar if you live out of state. Again, most of estate planning from state to state is very, very similar. So how can Copenbarger, how can we specifically help? Well, at Copenbarger, again, we are here to capture what matters most to you. What is it that you want to leave your loved ones, and how do you want to leave and live your legacy? We want to make sure that these questions are answered ahead of time so that it is left to no one but you once you are gone. We're also able to give you the tools to take care of your family as much as we're able, but we're also able to then, using our administration department, help them. So it is not just a you step that we're looking at accomplishing. We're looking at making sure the family is taken care of even after you are gone. We have been around for quite a while, just over 44 years now. And so we've also seen a lot of different scenarios. And so again, have a lot of different ways that we can ensure that you are taken care of and your family is that many other attorneys may not know are possible. A lot of this comes back to our administration department. That department gets to see, based on what other attorneys have done, what is, or unfortunately in a lot of cases, what does not work. And it allows us then to make sure before anything goes wrong, you and your loved ones and your assets will be protected. So thank you again for sitting and listening to me for these 50 minutes. We are going to hang out for a little bit. So if there's any other questions that you have, please put them in the chat or the Q&A. You will receive an automated call from us after this asking if you are interested in setting up a free consultation, either to get you started or to review your documents. We are very thankful that you took the time with us. I did get one quick question. So do we have a blank healthcare or DPA that we can fill out before coming into the consultation? So before the consultation, it's not the form itself, but you will receive our questionnaire that will ask questions as far as who do you want to serve in these different roles. If you can fill that out and bring that, that'll be perfect. And it'll allow us then to get your documents completed in a much more timely manner. Again, I'll hang out for a little bit here and we'll leave the chat open. We also do have a survey that we are going to be, it's already in the chat, perfect. If you can just answer a few short questions for us, letting us know, was this helpful for you? Is there anything else that you had wanted to see covered? Any other questions that you have, that would be great. It lets us know how these were and make sure we're really serving you to the best of our abilities. All right, got another question. On this one, it's, can you explain what is a life trust and when do you use it? I don't know if I'm fully understanding. So there's two times I could see using life trust. There's a revocable living trust, which is when most people create their trust. It's their document and they're able to make changes and revoke it in the future. We also use what are called lifetime protective trusts, which are the trusts for your children that insulate their inheritance from outside predators. If I'm not fully understanding the question, though, please do set up a phone call or at least a consultation with us. That way we can make sure that that gets correctly answered for you. Can I summarize the impact of Prop 19 and Prop 13? Basically, Prop 19 made it almost impossible for anyone to inherit a property and keep your property tax basis. There are very, very narrow and select instances where your properties are able to keep their property taxes, what you pay, rather than what the value will be after you pass away. So if you have any other questions on that and how to protect properties against Prop 19, absolutely set up a consultation. All right, I'm not seeing any other questions right this moment, but again, I'm going to hang out a little bit longer. Oh, here's a great one. What is the chance of Prop 19 being overturned? So we actually just did a webinar with the Howard Jarvis group, who is a tax group looking to overturn Proposition 19. They, I believe, still have openings for people to sign the petition to have it put back on the ballot so that we can hopefully overturn it. If you would like more information on that, I actually recommend writing in, especially on our website, to ask for information on that. We can then get you, if there are additional petitions to sign, we can hopefully get you one of those, or at least get you more information. Unfortunately, this proposition we were hoping was going to be put back on the last election ballot. They needed, I believe it was 1 million signatures, and we did not have the ability, they did not have the ability to get that full 1 million in the time we were allotted. We're hoping this time we have had a bit more of a headway on it. So we're much more hopeful, but it does take word of mouth and it takes people signing the petition to even get it on the ballot. Then it takes word of mouth and people voting to have it overturned. Again, I would very much write into our website, Copenbarger.com. We have a live chat there. And if you need more information on that, let us know. If you already have a trust in place, it depends if it was prepared by us or another attorney, but we're more than happy to review it and let you know. Is it completely up to date and is it good? Does it need to be rewritten, or do you just need to change a few things? It very much depends case by case, but you can absolutely bring it in even if it wasn't done by us, and we can have it reviewed. All right, and thank you. As I know people are signing off, thank you again to everyone who has taken the time with us this morning. Again, we'll hang out a little bit here and keep answering any questions that you guys might have. All right, I am going to sign off, but we are oh, no, I'm not. For the summary of how Prop 19 changed Prop 13, that was where I was discussing it's almost impossible for people to keep their property tax basis when it transfers to a beneficiary. For any other questions on that, absolutely set up an appointment. All right. Give it just 30 more seconds and then I will sign off. But as I mentioned, we'll leave the contact information up for anyone else who needs it. Other than that, I hope everyone has a great rest of their day, and we are here to help when you need it.